There it is.
By the way, for Audrey and Silver, rules of evidence, you know, when you see on TV the attorney says, I object, they usually object based on rules that have been pre-established for legal cases. And this is the way that we can control the trial and get the other team on the defense, or keep them from attacking us as strongly as they might want to. So this is how we interrupt and apply the rules in order to get them either off track or get us back on track. So with that in mind, I'll let Mr. Zeiger explain it in more detail.
You have a couple of experts at least. You have Terry Cloth, the medical doctor. You might have expertise in diving from that teacher. You might have a handwriting expert. All of those are subject to evidence rule 702, which is a very short rule. It's testimony by an expert witness. A witness who is qualified as an expert by knowledge, skill, experience, training, or education may testify in the form of an opinion or otherwise if the expert's scientific, technical, or other specialized knowledge will help the trier of fact to understand the evidence to determine a fact issue. Now, that's just basically one sentence, but the courts have interpreted that to require several steps, and it's my goal to set those out for you in a written document. But in an overview, the expert must be qualified, that is by training, experience, or education, and in a recognized field. A parapsychologist, psychic, could have all the degrees in the world from the Institute of Psychic Knowledge, and they're never going to testify in a Texas court because telepathy is not a recognized skill or area for expertise. So they have to be qualified. And then second, they have to connect their opinion to the actual facts. It's called the analytical gap. That is, if the expert just says, I'm an expert, trust me, Nano was competent when he wrote this will out, that's no evidence. And you would object to that it's that he's not giving an opinion that's relevant, connecting the facts with analysis. So if there's a gap between the conclusion or opinion, which only an expert should be giving on these issues, and the facts, or maybe there's not a gap, but the expert doesn't connect them, which creates a gap in the testimony, then the expert shouldn't be able to testify. So whenever you're putting on an expert or cross-examining an expert, and therefore making objections to the other side's direct, make sure that they're qualified, that their opinion is based upon the scientific or medical or whatever principles of their expertise, accounting, engineering, you name it, and their testimony connects the actual facts with their opinion to where you can see, okay, that's their reason. And if you make them do it right that way, you're going to chew up a bunch of their time, because it's so much easier just to put somebody up and say, you're a doctor, tell me, was he competent? Yes, he was. Pass the witness. I mean, that takes 2 seconds. But if you make them do it right, you're going to chew up at least 5 minutes of their time, and time is precious on this. That is, I think, the most complicated of the preparation, because the rule doesn't help you that much. You have to understand the evidence or the interpretation of the evidence behind it. Second is the dead man rule, which is 601. That is a person competent to testify. And when you have a case against a party in their capacity as executor, administrator, or guardian, or against the decedent's heirs or legal representatives based in part upon the decedent's oral statement, then you cannot testify about an oral statement of the decedent. And the reason for that is if you open the door, Mary would come in and say, he told me I was his favorite niece, and that he was giving everything to me, and yada, yada, yada. Well, the guy's dead. He can't refute it. So if death closes the testator's mouth, it also, in fairness, closes everybody else's for an oral statement. The key in this case to look for is, are you in fact dealing with a case against a party as an executive, administrator, or guardian? And you're not. You're two beneficiaries, potential beneficiaries, fighting it out. So you have to say it is about the decedent's heirs or legal representatives. You're not actually an heir because you would not inherit under intestacy. That is, if there was no will, would either of these parties, ACE or Ace, I've forgotten his last name, would either of them inherit if there were no will? The answer is no. So if that rule comes up, you need to be prepared, one, to get around the objection, or two, to explain how both of us are maybe not heirs at law, but both parties are claiming to be beneficiaries and therefore able to inherit. And I think you can throw some smoke up there that'll cause the other side to get a little bit confused, and that's always good.
Good.
All right. The third one is, and this one is covered in some detail in the handout on how to use your evidence, and that is how to impeach a witness. And generally, an impeachment could be either they're not qualified to testify, that is, they're insane or unable to form their a rational opinion like a child. You probably won't have that. The second one is they weren't in a position to have personal knowledge, and therefore they can't testify. So if they say, yes, we did this, or I observed so and so, and you have evidence that they were in a different state, we're impeaching them by their inability to do that. But the most likely in your case, and the usual impeachment that you will deal with in this case, is a prior inconsistent statement. And you have a whole notebook full of statements that they've given. But I mean, I don't know how y'all do it in high school, but when we did it in law school, you skated as close to that statement as you could to give it as much color and twist to help your side as you could. And that creates the opportunity to impeach. And by impeaching on a prior inconsistent statement, that's evidence rule 613, it tells you exactly how to go through that. You would first tell the witness the contents of the statement. Mr. Witness, I hold in my hand your sworn statement. Two, you tell them the time and place of it, which you signed thus and such a date, whatever it is at the bottom of it. And you made that statement in connection with this case. So you tell them that. And then second, you tell them what they said. That is the contents of the statement. This is what you said at that time. Isn't that correct? But then you have to give them the opportunity to explain. So if your witness is being impeached and they say, and that's what you said, right? And then move on, you object. So, Your Honor, under Rule 613A3, the witness must be given the opportunity to explain or deny the inconsistent statement. And you can't deny it. That's part of the stipulation. So explain it. So that's just remember those steps. You have to tell them what they said, when they said it, and who they said it to. You don't have to hand them the written statement, although the court can require that. An opposing counsel can ask for it. And then you have to give them an opportunity to explain and be prepared to insist on that if you're presenting the witness being impeached. A separate impeachment is bias. And of course, anyone who stands to inherit umpty-fret $1 billion is going to have an economic bias, and that's pretty obvious. Generally, you just point that out. It's a you're saying this, but isn't it true that if they go with you, you're gonna be a multi-billionaire, right? And that's a strong motive to you, right? That type of question. And that's I mean, they can explain or deny it, but it's kind of hard to in a modern world to do that. And then lastly, I want to talk to you about opinions by lay witnesses. I told you expert witnesses, and you've got 2 or 3 of them, have a particular standard. Lay witnesses, those who are not experts, who aren't accepted as experts, are held to a different standard than laymen. A lay person cannot give an opinion unless it is rationally based upon their perception and helpful to understand the testimony to determine the fact question. And what that means is they cannot get separate facts that they weren't present to watch or see or know and then opine. So, I've known Nano for 30 years, and based upon Dr. Terry's examination, in my opinion, he was competent. Well, you can't do that. But if you say, I've known him for 30 years, and this particular writing or statement or whatever is typical and very consistent with the way he did, and is not in any way reflective, from my experience, of any lack of capacity or mental acuity. See the difference? You're telling it based on your experience. That's Rule 701. And I think you ought to, I think those rules will cover most of what you want. I'll give you 2 more comments, though. And one is Rule 402. I'm sorry, 403. 403 is a catch-all rule. It's incredibly useful if they bring up something new that is harmful. Let me give you an example. Nano lived longer than, I'm sorry, I don't remember the names very well. The other guy in the submarine. And there, in his notes, he talks about the guy quits breathing. There's a point where he says that. And there's a certain amount of oxygen that would have probably run out, if my math is right, for both of them being alive all the way through. Now, part of the argument of Nano being strong, and he passed all these tests, is he was breathing better, he was doing better, and the other guy was a couch potato and didn't do well, and that's why he died early, which left more oxygen for Nano. What if someone presents a speculation that Nano choked him to death so he would live longer? Now, there's nothing in the record to support that other than Nano lived long. That is total speculation. Rule 403 excludes evidence that would cause confusion, prejudice, or unfair. And that's an objection that if somebody throws up something that is off the wall, you haven't thought about it, it's not supported, and it's prejudicial, cite Rule 403. The court may exclude relevant evidence if its probative value is substantially outweighed by a danger of one or more of the following: unfair prejudice, confusing the issues, misleading the jury, undue delay, needless cumulative evidence. So think about that if someone throws a curveball. I'd like you to really think through that. And then last but not least, the procedure. I don't know if they'll let you take a witness on voir dire, but in Texas, particularly if an expert is up there giving a testimony, you can interrupt the direct testimony to object on the qualifications and request the court to let you take them on voir dire and do a mini cross-examination right there in the middle. And the voir dire means I want to ask them questions about their competence, qualifications, or analytical gap in their reasoning. And if the judge knows Texas law, they'll go, sure, go ahead. Choose up your time a little, but it also disrupts them as you get to challenge that expert right in the middle of their testimony. And then you move the court after that, move to exclude the testimony, to strike it and instruct the jury to disregard. court doesn't always grant that. I mean, this is moot court. They really need to let all the people talk so that they'll all have that experience. But it's a great maneuver that I encourage you to use as appropriate. Last but not least, Dean, I have printed out an extra copy of the statements. One of the things I don't want to do everybody's work for them. I certainly don't want to be overreaching on this, but I was going to go through and highlight 4 or 5 spots where I thought, here's a place where you can make this objection. Here's a place where you can make that one. Not all of them by any means, but to illustrate what I'm trying to show with absolutely applying to where you are, if that's acceptable.
That is acceptable.
Yeah, unlike coaching sports, I actually can do the work for them. I can't play on the field, but I want to be careful that I don't step over. All right, I'm open for questions, and then I'd like to make a couple of comments about the open.
Are there, I think you said once there were particular objections that worked better for particular sides of this case? Is that true, or is that oversimplified?
I think it might oversimplify a little bit. It actually depends upon the witness. You need to be prepared to address the objection or to make the objection on either witness. There are some objections that fit witnesses better. Some witnesses clearly will have hearsay, which I didn't get into because we don't have a whole lot of that. Hearsay is an out-of-court statement offered to prove the truth of the matter asserted. It's Rule 802. And it's, if I say, Bill told me, well, that's hearsay because Bill's not here testifying, or a written document. But there are so many exceptions to it that there are 26 exceptions, I think, that it's a minefield. And if you get into that, you will spend a lot of your time on rabbit trails.
Yeah.
But I'll identify a couple of places where hearsay seems obvious, and you'd cite Rule 802, and the other side would cite Rule 803 for an exception, the present sense impression, or whatever it is.
The other question I had too is that when you can ask the opinion of an expert witness on a particular matter that they're an expert in, and have that as being allowed in the trial, but you can't ask the opinion of a non-expert witness or an expert witness on something they're not an expert on in a trial. Is that correct?
You have succinctly stated it. That is the rule.
Okay. I just wanted to make sure I remembered that right. So, okay. Do you guys have any questions about rules of evidence?
I have kind of a weird question.
By the way, Nathan, I have emailed the gentleman who's providing answers for us on those questions, and probably won't hear back till Monday.
Okay.
Okay.
So there's a bit in Northshire's testimony that it makes the testimony a little bit hard to handle, because I think it is an important part. Because the thing is, Northshire has examined what he calls this essentially has to do with like the limits of Rule 703, and hold on, I'm trying to find. Okay, so it says that Northshire has studied the medical and observational reports about Nano during the time prior to the dive, and then he says that because Nano appears to have forgotten people's names, failed to recognize places he had been numerous times before, like the incident at the tower, that in his opinion, this would indicate symptoms of general dementia. So the problem I'm running into here is I'm fairly confident that that's going to draw an objection based on hearsay, because obviously, I mean, I'd say rather obviously. So I'm not sure if the correct response would be that that's an exception under Rule 803-4, that it's a statement made for medical diagnosis, or that we're not asserting that for the truth of the matter asserted, but it's opinion testimony from an expert drawing conclusions from data that the expert has been made aware of, according to Rule 703.
Yeah, Rule 703 allows an expert to rely upon hearsay testimony that's otherwise inadmissible, as long as it is the type of evidence that or information that experts in that field routinely rely upon.
Okay. So if they object to hearsay, I would just say that it's permissible under 703.
You would say, well, you need your expert, Northshire, to tell you that, yes, this is the type of information
Okay.
that, what do you get? Neuroscience and forensics and PhD. Yes, that experts in this field routinely rely upon. I will tell you your big problem with Northshire is he does not give, his statements don't give his testimony in the form of reasonable scientific probability. He says things like, in this case, I believe Nano was exhibiting clear signs. His belief is not testimony that is normally permitted. He would need to testify that in this case, based upon my review of the relevant information, based upon my training and experience, and based upon the facts as set out in my report, in reasonable medical or reasonable scientific probability, Nano was exhibiting mental clear signs of mental abilities. When he qualifies it like I believe, or he may have become, etc., that weakens it to the point it may not even be admissible.
So can you correct that in the direct questions by asking him those types of questions specifically?
Yes, the way I usually do that is I begin after qualifying him and say, okay, Dr. Northshire, going forward, I'm going to ask you about your opinions based upon the evidence, your review of the records, your training and experience, and I want you to give me the answers in terms of reasonable scientific probability based upon your training, experience, and the evidence. And then after you give the opinion, I'm going to ask you to explain the basis for it a little bit better. And then you'll say, based upon your training experience, et cetera, do you have an opinion if Nano's mental abilities were impaired prior to the dive? And the answer is yes, I have an opinion. And then you say, what is that opinion? They absolutely were impaired based upon my training experience, reasonable scientific probability. Explain why. And then he can go, okay, he was exhibiting signs in September to October. He had a minor psychotic break for 2 full weeks, et cetera, et cetera, et cetera. You see how that comes together? You don't just have him testify, I believe. You have him agree that everything he says is based upon an appropriate standard, which is the reasonable scientific probability of neuroscience and cognitive neuroscience. And then you go forward with the questions.
Okay, thank you. That helps.
Olivia, do you have any questions?
No.
Okay. Does this make sense to you, Silver, somewhat? I know this is all new, so, okay. So, do you want to go into the opening statements, Mr. Zeiger, and share some
I
of your thoughts?
wanted to suggest 2 principles that will beef up anybody's opening statement. And the first one's called the rule of 3. If you look that up on Wikipedia, basically it's that human beings connect up 3s better than they do 5s, 10s, or 1s.
That's right.
One of the greatest speeches ever given, the Gettysburg Address, is a good example. All men, I mean, it starts with foursquare 7 years ago, but it's government of the people, by the people, for the people, shall not perish. We cannot dedicate, we cannot consecrate, we cannot hallow this ground. Those brave men living and dead who fought, etc. It is a good example of how President Lincoln used the rule of three, three synonyms or three contrary things. Blood, sweat, and tears. Life, liberty, and the pursuit of happiness. Those resonate with us, and it's easy to remember if you do the rule of threes. And the next thing I want to suggest is alliteration. If you don't have to be a poet, but if you use alliteration with your rule of three, you compound the memorability of what you're saying in your opening statement. Now, that has nothing to do with your content. That has everything to do with the presentation.
Style. Yep. And figures of speech are very good at making things look and feel better to the people who are listening. Also, there's the Father, Son, and Holy Spirit.
Yes.
There's grammar, logic, and rhetoric. There's logical appeal, ethical appeal, and emotional appeal. It's all the three is a magic number, and you see it often. So.
And we want to see it in all of your openings.
Yeah,
because it resonates. It has power. It has memorability. And of course, you're telling a story, and you're starting with the person that you want the jury and the judges to connect with. That's who is the person you start with the story. If I wanted the jury to connect with a fellow who was driving his car and a crazy college student high on drugs ran a red light and killed him, I would not start the story by saying John Smith was a college student taking courses in education and mathematics when he got drunk, etc. I don't want you to care about him. I would start with Bill Jones was a father, and he said goodbye to his wife and kissed his children and went on his way to work, not knowing that he would leave them a widow and an orphan in 15 minutes. See the perspective. Start with who you want the jury to identify with and consider.
Good. So, Nathan, is your opening statement, you're in Sterling, and Kayla's opening statement, is it, or Sterling's, is it done?
Unfortunately, I'm not sure. I know I've asked for them to be put in the Google Drive, but I don't think anything has been.
Okay.
So
that's okay.
I mean, I can ask Sterling right now. I don't think he'll answer.
Well, he's not on, so I don't know what's going on with Sterling, but he hasn't said anything to me. But that's fine. I will ask too. Okay.
Okay.
So I'd like to be able to have some direct questions next week by this time, and those statements, at least good rough drafts of those statements up.
Okay.
On that.
I have a very rough draft.
Okay.
Of my direct. So
okay,
if y'all want to look at that,
that'd be great.
Just over the week, that might be good.
And you sent that to me last week, right?
The very rough draft of the direct. Oh, the Google Drive. Yeah.
Okay, good. Then I've got it. So, does anybody have another question? Okay, then I'm gonna go ahead and save this recording when we're done, and then I'm gonna send it out to y'all, so you have it as a resource. And then, Mr. Zeiger, could I speak with you a little bit when everyone else goes, just to ask another question?
Sure.
Okay, so you guys are free to go and continue enjoying your Thanksgiving. Okay, thanks for coming on. Remember, December and November are really where the foundation is built for the future, for what we do in January. So the efforts and the sacrifices you're making when other students are celebrating their holidays is appreciated. You're going to be paid back for it. Okay, so good job. Thank you. And we'll see you next week.
Bye.
Bye.
All right.
Just so I'm not sure exactly what the line is, because what you said was you actually can do the work. It's not like teaching basketball. I think we can lead the horse to water, but they still have to drink it. They got to go out there and argue the case. We can't be involved once the case starts, and they have to do it. So I have helped them with writing revisions at times. I've given them ideas. And I think that I'm just trying to help them with what I know. And I think your idea about what objections would work best with which witnesses and which parts of the case, I think it's reasonable to show them what we think would be best. But then ultimately they're going to have to go out and make it work.
Okay.
Does
Well,
that make
what I'll
sense?
try
'Cause
to-
we're not going to be able to do it for them, and we can't interfere with them at all during the trial.
Well, yes, that part's true, but I also don't want them to be quoting me instead of making their own argument.
Exactly. It has to be paraphrased and in their words. But for example, if you wanted to, I don't know if this is what you were thinking, but it's what came to me when you mentioned it. If you were going to go through a witness statement and say possible objections, like objection 701 or rule 701 or rule 7, as an example, I think that's just providing them with insights and thoughts, but you're not writing in your words when you do it. Or that's an idea.
Yeah, I could see that if I went through and typed up the objection, Your Honor, I object based upon, et cetera. That would be way over the line. But if I highlight it and say, possible rules to look at, Rule 702, Rule 613,
Right.
et cetera. What I did want to emphasize is Rule 403 is you're not going to be able to find that on the statements. It's when someone jumps the track. That's when you pull that out as your emergency go-to.
Right. It's good to know that. So I wasn't aware of that. So that was great. I thought that was really good information.
And it, people try to get clever. They try to get as close to the line. In the heat of a battle, somebody will say something that went off script and surprise everybody in the room. And then you pull out 403. Yep.
Right. That's great.
And that's helpful.
Well, that was really super helpful. Okay. And I appreciate all the efforts you're making and the sacrifices you're making. It means a lot. And I think it's going to be the dividends are going to show when we get into trial. So super excited.
Well, I think it's useful for the kids to learn not just the public speaking, but the thinking on your feet.
Yep.
And the sense of accomplishment in an intellectual pursuit. I'm very much in favor of them having this experience. I think the experience itself is valuable.
Mock trial gives you a lot of real world experience too, doesn't it?
I thought it did.
Yeah.
Yeah. When we won the Baylor mock trial, it helped set us up. I was sworn in and tried my first lawsuit. That was, 40 years ago, you could do that. Now it's harder to get to trial. I was in a small town up in the Panhandle, was able to do that. And because I had the experience of the mock trial, it was new. I had a real judge, real case, but it was also familiar. And they may never be lawyers, but they will have a situation where they're making a presentation to the president of the company or to a board, and someone will throw them a curveball. And they have to say, okay, I prepared for this. I thought about what people would say. I had it ready, and I can answer that. Because it translates, I think, through any effort to persuade or to present. And almost all of us do that at some point. if only to explain to the girl's parents why you're a suitable suitor.
Yeah, that's good. Well, very good. I agree with you and appreciate your help. And I hope you enjoy the rest of your day with your family, okay?
I will. Thank you so much.
Okay, have a great day. Thank you.
You too.
Bye-bye.